Mr. Newland, were you with the defendant on this morning in question?
Yes, I was.
What did you plan to do on that morning?
To steal hubcaps.
Did the defendant Harley know anything about your plan?
No, not exactly. I told him that the car belonged to a friend of mine and that I was collecting a bad debt.
That was all that you told him on that morning, is that correct?
Yes.
And that was all that he knew up until the time of the arrest, is that right?
That's right.
No further questions, Your Honor.
You may cross-examine the witness when you're ready.
The prosecutor also has the chance to cross-examine witnesses.
Mr. Newland, did Defendant Harley agree to help you take those hubcaps?
Yes.
Did you and Defendant Harley talk about this matter after you were arrested?
No.
Did you ever tell the police the story that you've told us today?
No.
Isn't it a fact, Mr. Newland, that you're just concocting this story today in order to save Defendant Harley because you've been arrested and convicted in this charge and you feel you have nothing to lose?
The story is true.
I have no further questions.
The Bill of Rights states that no person can be forced to give evidence against himself. The accused does not have to testify at his own trial unless he chooses to do so.
Were you with the man Newland on this morning in question?
Yes, sir, I was.
Did you know anything about his plan to steal hubcaps on this morning?
No, sir, I didn't know of any plan to steal anything at all. We were on our way to the college cafeteria, and I was going to meet a friend there. And he said he noticed the car, that he knew the owner, that owner owed him money, and that he was going to collect the money by taking those hubcaps. But he didn't say anything to me about stealing.
You didn't intend to steal any hubcaps at all?
No, sir. No, sir.
No further questions, Your Honor.
The prosecutor may cross-examine the witness. Mr. Harley, did Mr. Newland ever tell you who owed him the money or what the debt was for?
No, sir.
Is this the way that you would collect the debt, Mr. Harley?
Objection, Your Honor. The question is argumentative.
The objection will be sustained.
A lawyer can object to a question. If the objection is sustained by the judge, the witness does not have to answer the question. If the objection is overruled, the witness must answer.
Didn't you first tell the police that you were really replacing the hubcaps and not taking them off?
Yes, sir, I did.
Is that story a lie?
Well, yes, sir, but the reason I told him that was because I was frightened at the time. I didn't know what to say.
Have you ever told any police officer or anybody else this story that you're not telling us today?
Objection, Your Honor.
The objection is overruled and the witness may answer the question.
No, sir.
I have no further questions. Defense counsel may argue to the jury at this time.
Ladies and gentlemen of the jury,
After all the witnesses have been heard, the lawyers have the right to sum up their cases before the jury.
the court will instruct you on various points of law, one of the most important of which will be that one cannot be convicted of a criminal offense unless there is a finding of a criminal intent. Burden of proof that you will be instructed is on the prosecution to prove this case, every aspect of it, beyond a reasonable doubt. I submit to you that that proof has not been shown to you. There is no doubt in my mind but that you should bring in a verdict of not guilty. Thank you very much.
The prosecution has proved today, and the defendant has not denied the following facts. That both people were found at the scene of the crime. Newland was taking the hubcap off, and the defendant was holding the hubcap. When they saw the police, both men ran. When they talked to the police and told their stories, Newland failed to tell the story that he told you today, and the defendant lied. You are faced today, ladies and gentlemen, with the proposition of believing the defendant's story, and I think the story is unreasonable. I therefore ask you to find the defendant guilty as charged. Thank you. Ladies and gentlemen of the jury,
The judge then instructs the jury on the various points of law that apply to the case.
and in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to an acquittal. But the effect of this presumption is only to place upon the state the burden of proving him guilty beyond a reasonable doubt. Reasonable doubt is defined as such. The jury room
you will select one of your fellow jurors to act as foreman, who will preside over your deliberations and who will sign the verdict to which you agree. As soon as all of you have agreed upon a verdict, you shall have it signed and dated by your foreman, and then return with it to this room.
After the jury has been instructed by the judge, they must decide whether or not the accused has broken the law. This is done in secret, so that no one can influence their decision.
I understand the jury has reached a verdict. Will the foreman of the jury please hand the verdict to my bailiff?
People at this state versus Roger Harley. We, the jury of the above entitled cause, find the defendant, Roger Harley, guilty of the offense charged to wit, Section 484 of the Penal Code.
According to the Bill of Rights, a person convicted of a crime cannot be given a cruel or unusual punishment.
This is the time for your sentence, Mr. Harley. Is there any reason why the court not pronounced death on you at this time?
No, Your Honor.
I feel, Mr. Harley, that you probably wouldn't have been in this trouble and wouldn't be here today if it were not for your association with Mr. Newland. I hope that this is going to prove a very valuable lesson to you. You must be very careful who you pick as a friend. The court, however, is going to take into consideration the fact that your record is good. This is your first offense. And I'm going to suspend the imposition of sentence in your case and place you on probation for a period of 1 year, on condition, first, that you be a law-abiding citizen in all respects, as apparently you always have been. Secondly, that you pay a fine of $110 or that you serve 10 days in city jail. I consider that to be a rather small fine and small sentence. But I want to promise you that if you ever do this again, it's going to be quite different next time. Quite different. And of course, the court sincerely hopes that there won't be a next time. That's all.
Thank you very much, Your Honor.
Being placed on trial for a criminal offense is a serious matter. This is why the rights of the accused are protected during arrest, arraignment, and trial. The accused has the right to reasonable bail. He is informed of the charges against him and given a fair trial. He can call witnesses in his defense, has the right to a lawyer, and can face his accusers. The Constitution, with its Bill of Rights and the laws of the United States, protect an accused person just as they protect us all.